Did the Cowichan decision just break property rights in British Columbia and in Canada? In this video, I'll show you exactly why the Cowichan Tribes decision could turn your property rights upside down and what you must do right now in order to protect yourself. My name is Richard Morrison, and I've been a leading investor in real estate for over 25 years across the United States and in Canada. I've closed deals valued over $230 million for myself and my clients. And I've just attended a presentation by constitutional lawyer John Weston that decoded the most dangerous property ruling in Canadian history. Here's what most investors don't know yet. $85 billion just fled Canada in the first half of 2025 alone. And that's not a typo. In this court case is adding gasoline to that fire. Because on August 7th, 2025, a BC judge declared that fee simple title, the bedrock of property ownership in Canada, can be defective and invalid. Now, let that sink in, because here's what we're covering today. The Cowichan Tribes case just ruled that Aboriginal title can override your deed, even on property rights that you bought in good faith. Now, this affects 150 private properties in Richmond right now. But the precedent could ripple across every parcel of land in British Columbia and maybe even across all of Canada. So I'll walk you through what the court case actually said and maybe what it means for developers and investors and the 5 due diligence steps that you need to take right now before your next property deal. Now, this isn't fear-mongering. It's just financial survival planning. I've guided my clients through the 2008 financial crisis, during the COVID crisis, and during the latest crisis that we've had recently in 2022. They didn't just keep their money safe, they actually thrived. And by the end of this video, you'll know more than 99% of real estate professionals out there. Now, what the courts actually said, the case lasted about 513 days in trial. And that's probably the longest trial in Canadian history, by the way. Over 60 lawyers, and I think it was something like 900 pages of judgments. Now, the bottom line is that the court found that the Cowichan Nation holds Aboriginal title to lands on Lulu Island, which is now part of Richmond. Now, here's the kicker. The judge didn't just recognize Aboriginal title. She said that Crown grants of fee simple title over those lands are defective and invalid. Now, this is unprecedented because for the first time in Canadian history, a court ruled that Aboriginal title can supersede fee simple title. But here's where it gets messy. Aboriginal title comes from occupation before European contact. Fee simple title comes from Crown grants, the Torrance land title system that we all rely on. And until now, we thought these couldn't coexist. But our BC judge says they can. Therefore, we now have a legal framework where 2 parties can hold exclusive rights to the same land. How does that work? Nobody knows yet. And that uncertainty is leading investors running for the exits. A few people are selling, and if they're not selling, they're planning to sell. Why does this matter to every developer and to every homeowner out there? Because most developers assume that if they buy a property with clear title, they're protected. But neither the BC government nor the federal government argued at trial that Crown grants extinguish Aboriginal title. Only the city of Richmond made that argument. Therefore, if this decision stands on appeal, it sets a precedent that could affect any land in BC or in Canada, where First Nations can prove historical occupation. And that's a lot of land. John Weston said something chilling in the presentation, that all our fee simple security emanates from the Torrance system. If there's no theory of Crown grant rooted in Canadian constitutional law, then look out. Here's the translation. If Crown grants don't extinguish Aboriginal title, then the entire foundation of property ownership in Canada is on shaky grounds. And the market is noticing. Just this year, the first half of 2025, $85 billion in net investments outflows came out from Canada. That's 3% of Canada's GDP. That's larger than the full year outflows during the 2008 financial crisis. So capital is really fleeing Canada after this decision, and with many other decisions as well. I led investors through the 2008 financial crisis. I saw what that panic looked like. And although this doesn't feel the same, it is definitely something that we should be careful and to watch out for. Here's the 5 due diligence steps that you could do right now. So what would you do? John Weston laid out a roadmap for investors navigating this mess, not just investors, but also homeowners such as yourselves. So here are the 5 steps. What you could do is a historical survey of your land, or maybe perhaps where your property sits on, the land that your property sits on. Or before you buy any property, research the history that that land is in. So you can check out the BC Land Title Office to check out the history. You can also visit local libraries or search online archives, and you'd be surprised what you can find there. You can meet with local First Nations as well, and that could feel quite awkward, but you need to know who has potential claims on that land. He also mentioned not to show all your cards, but do get a sense of what they think their rights are. And make sure you use a non-disclosure agreement if you're buying that piece of land or if you're sharing confidential information, because you want to make sure that no information gets leaked out. A third step you could take is consult with the BC government's land planning department. The province has regional offices that track First Nations claims and treaty negotiations. They won't have all the answers, but they'll give you a starting point. Step number 4 that you could take is allow enough time for consultation. So Canadian law requires consultation with First Nations before development. But here's the twist. BC adopted the UNDRIP legislation in 2019 that requires free, prior, and informed consent. Not just consultation, but also consent. So nobody knows what that means yet because the courts haven't been descriptive of what consent means, but it's certainly a higher bar than consultation. You should also budget extra time and money for this process because as with all permitting and processes in British Columbia, it can take quite a long time, right? John said something that struck the room in that presentation that night. You may have to financially support the First Nations you're dealing with so that they can afford the consultants they need to negotiate again. So let me repeat that. You may have to financially support the First Nations that you're dealing with so that they can afford the consultants that they need to negotiate, which means you might have to pay for the other side's lawyer and consultants just to get a deal done. That's the new reality in British Columbia. Will the appeals court save us? Everyone's pinning their hopes on that appeal. BC, Richmond, and Canada. The Cowichan Tribes are also appealing different parts of that decision. But here's the problem. To overturn this decision, the Court of Appeal has to find the legal error in that 900-page ruling that I mentioned earlier. And remember, BC and Canada didn't argue that Crown lands extinguish Aboriginal title. The only city, the little small city called Richmond, was the only city that argued that Crown land grants extinguish Aboriginal title. So there may still be hope. Can they raise that argument on appeal if they didn't raise trial? Maybe, maybe not. It's definitely a gray area. But John Weston did mention that Richmond did raise that argument during the courts, so they may be able to bring it up once again. And even if the appeals, if the appeals succeed, John Weston believes that the real solution is really not in the courts. Therefore, he's calling for a constitutional amendment. That would require the federal government plus 7 provinces representing 50% of the population to agree. So we may be heading to a referendum on the issue. And that's a heavy lift. But he thinks that it's the only way to restore certainty to property rights in Canada. What about title insurance? John addressed this. Does title insurance protect you? He doesn't think so, but it could. Title insurance covers defective title, but this isn't a defect, so it's kind of complicated. And it's a competing claim of ownership. And most title insurance policies have exclusions for Aboriginal title claims. So probably not. You're probably not covered. The bottom line is that insurance are meant for title defects and not necessarily a shared ownership. So here's the bottom line of what you need to know regarding this. The Cowichan Tribes decision declared Aboriginal title can override simple fee title. That affects 150 property owners right now in Richmond. However, this precedent could apply across British Columbia, maybe even across Canada. $85 billion have already fled Canada in 2025 because of uncertainties like this. And the appeal will take at least minimum 2 years. And even if it does succeed, the underlying legal uncertainty remains until we get a constitutional fix. And in the meantime, you must do your homework. Follow the 5 diligence steps that I've outlined in this video. And definitely don't assume that clear title means that you're safe. If this video has helped you to understand the Cowichan case, hit that subscribe button and make sure you like this video as well. I'm breaking down real estate stories that affect you and your bottom line. No fluff and no BS. Drop a comment below as well. Are you currently experiencing some issues in this case? Or are you looking for property that is affected by this particular case as well? Let me know. And if you want the full transcripts and links to all the sources that I've cited, make sure you check the description below. This is Richard Morrison with 25 years experience leading investors in real estate in the United States and Canada, with over 230 million deals closed. Still learning and still fighting. I'll see you in the next one.